least 99% of the cases are being filed in California, either in state court or in federal court.
And does it matter then whether a person themselves is from California if they're filing a case in California?
The answer is it matters, but there's something you can do about it. Under a recent decision 2 years ago by the United States Supreme Court, Bristol-Myers versus Superior Court of California, the United States Supreme Court said that if you're going to sue a company and you don't live in that particular state where that company is headquartered, you can only sue if the company is from that particular state. And so they need to have a headquarters there or a principal place of business there if you want to sue that company and you don't live in that particular state. In this case, Gilead is from California, so you don't need to live in California to bring a cause of action against Gilead in California because that's their home base. And you can sue a corporation in its home base even if you don't live there.
Let's talk a little bit about the status of the litigation. Are these class action lawsuits?
Many people get that confused. They confuse a class action with a mass action. A class action is something that occurs when the damages are readily identifiable. So let's say you have your Otter case right here, and the handle breaks off the Otter case, and I have an Otter case and my handle breaks off, and you have an Otter case and your handle breaks off. And we realize that this is a bad Otter box, so I could bring a lawsuit where it would read, Michael Monheit individually on behalf of all others who have defective Otter boxes. And so that's the class action where everybody can get a new Otter box back where the damage is identifiable or fungible or easily determined. And a class action is a really good mechanism for that. A class action is not a good mechanism for a personal injury case because if I were to get kidney damage and you were to get kidney damage, we're two different people. I may have had a history of kidney problems, you may not have. You have younger kids, I have older kids. So we have all sorts of different damages and injuries as people. So class actions really don't fit in the personal injury model. So what happens is every person who's been hurt gets their own lawyer. And so you and I will share a client, another lawyer may have a client, another group of lawyers may share a client, but they each have their own individual lawyer and in each individual contract with that lawyer. So those,
do they have an individual complaint and an individual filing?
They do, and so your name will be on a complaint that's filed in California if you retain a lawyer to represent you. Now, it doesn't have to be filed in California. You can file in your own home state where you live, but there are strategic considerations, and so far the lawyers have chosen to file in California because that's where Gilead is. Does
it ever occur when a complaint's filed that more than one person is part of that one complaint?
The answer is it depends on the state. It's a bundled complaint is a document that starts the lawsuit, and if it's bundled, you can put more than one person on the complaint. So we can represent, up to 99 different people and put all of those people on one complaint. In California, those courts permit you to do that. That's a great mechanism. Not all states allow you to do that.
Will that result in there being 99 trials or one trial? Does each person still have their own claim?
Each person still has his or her own claim. You're not going to have a trial with 99 people or necessarily a trial that's joined with any other person. Now, many plaintiffs' lawyers, including myself, think it's a good thing when you can get many people together in a bundle trial. We think that that's a useful and a good mechanism for moving cases along quicker. But you have a right to your own individual case. That's correct.
Rod, how many cases have been filed in California so far?
So there's a difference between federal court filings and state court filings. In the federal court filings, there's about 291 plaintiffs who have filed in federal court, and those, again, are in bundled complaints. There's not 291 individual complaints, but there are 291 plaintiffs. In the state courts, where you and I are filing our cases, there are approximately 900 people who have filed cases in the California state courts.
So altogether, about 1,200 claimants so far have come forward.
That's about right.
And are the cases grouped together in front of one judge, or do they get spread out throughout the whole state?
In the federal court system right now, the cases are consolidated before Judge John Tiger. He's in the United States District Court for the Northern District of California in San Francisco, an excellent jurist who's actually made some very good rulings for the federal court consolidation so far. The state court system is very similar in that there will be a consolidation before one judge, and there is a process where there's oral argument and then a request by different lawyers to go to certain different counties. That process is going right now, and so we expect to hear any day as to where the coordination of the California cases will be.
So they get coordinated in front of one judge, and that's something that should be known in the very near future.
Absolutely.
How long will all of this take? I mean, I know the answer, and I know why you're laughing, because these cases take a long time.
Regrettably, it is not unusual for cases to go 4, 5, 6 years or more. Believe me, we're working on a contingency fee here. There is nothing that we want more than to settle these cases as quickly as possible. But things take time, and the court systems move slowly, and the defendants have every incentive to drag things out. And so it is our daily struggle to push things along as quickly as we can, and certainly that's our goal in this case as well.
Let's talk a little bit about the phases the case goes through that helps people watching this understand why it does take so many years. So I guess the first step is a person realizes they have an injury and they go hire a lawyer.
They do.
What happens next?
As we said, we'll get the medical records. Sometimes we'll talk with an expert consultant, make sure that we have a good faith basis for moving forward in terms of making sure we have product ID, making sure that that we're claiming the right injuries, that there are not too many confounding factors that would make it difficult to make a causal relationship between the tenofovir and the individual injury. Once these lawsuits are filed and there's an accumulation of them, as you mentioned before, will all be coordinated for a single judge in California.
And what begins to happen in terms of an investigative process in front of that judge?
Okay. The judge will set up a schedule for what's called the discovery phase of litigation. And in the discovery phase, a number of things happen. First, we'll submit written questions and requests for production of documents. Those questions are sometimes called interrogatories, where we ask them questions in writing and the defendant has to respond under oath. And they submit interrogatories to our clients and we have to answer them under oath. And we request an exchange of documents. They'll ask for our medical records, we have to give that to them. We ask for their internal documents, they have to give them to us. That always comes with years and years of fighting to get the documents that we think we're entitled to, but that's the system. And that's the discovery system, which then will move on to include in discovery taking depositions. And a deposition is an opportunity to ask a witness a question under oath, and it's done in a conference room just like this one, and if not this one, where the lawyers come in from both sides. We want to ask questions of the people who worked at Gilead. They want to ask questions of our clients. That's all done again in a conference room with a court reporter, and the information is taken down and transcribed. So we have interrogatories, exchange of documents, depositions, and then we'll start to look at experts.
What sort of people within Gilead will get deposed?
Well, what we're interested in this case, of course, is people who are in research and development. Who are the people who are looking into the TAF drugs? What information did they have, and why come to the decision that the TAF drugs should no longer be used? All right? What science supported the decision to drop the TAF drugs? And so we'll look at research, development. We'll look at the regulatory people. Those are the people who had communications with the Food and Drug Administration. We'll look at the people who were in marketing, who were in charge of selling and selling the drugs to the physicians. What were they telling the physicians about the TDF drugs, whether they were safe or not? People who are in charge of making the warning labels. Those are the type of people we want to chat with.
I know that many mass torts, along the way, there's a document called a plaintiff fact sheet. Tell me a little bit about that and what role the clients actually have to play in terms of providing information.
Right. So in some litigations, Mike, the parties will agree and the court will order that a plaintiff complete a plaintiff fact sheet or a PFS. A PFS can be 10 pages, 20 pages, 50 pages long, asking excruciating, minute detail of every plaintiff's history, medical background condition, every symptom they've ever had, every drug they've taken. And if the court requires us to fill out an extensive plaintiff fact sheet, we have to do it. And you and I can't do it by ourselves. We need our clients on the phone, speaking with us, speaking with our lawyers, our paralegals, to get this information. If you are tasked with completing a plaintiff fact sheet, you must do it, or your case will be dismissed. It will be thrown out. It is not a function of whether it's nice to do it or we want to do it. It must be done. It has to be filled out fully, or your case is at risk of being tossed.
What sort of motions will we probably face from the defendants along the way as part of the process of getting our complaint, ruled on by the judge that it's acceptable, and in getting documents that we want? What are the different things that the shenanigans, in a sense, that we're put through, the delay tactics that we face?
The defendant's favorite tool is what's called a motion for protective order, which means we want something and they don't want to give it to us. And so it's always a constant battle for us to ask for documents. Like we might ask for the adverse event reports, which are reports that a company may either receive or send to the FDA, letting the company know that somebody's been harmed. And so we're going to say, give us all your adverse event reports so you can tell us when you first started getting reports of kidney injuries and bone injuries. And so we ask for those, and oftentimes we'll get a motion for protective order because they don't want to give us that. They don't want to give us their internal emails talking about dangers and risks. They might say that the case is preempted, which means that we don't even have a cause of action because the federal government is involved, and they try to kick us out on preemption. Experts also play a role in motions.
Getting your experts approved to be able to give testimony in the case.
Right. Depending upon whether you're in the state court or the federal court, different standards apply as to what you need to prove to get the court to accept your expert witness as somebody who's providing evidence that is generally accepted in the scientific community. State courts and federal courts have vastly different rules for that, but it is something that we face, and it's a burden that we have, both the plaintiffs and the defense, to bring forward qualified experts who rely on science that's reliable and accepted in the community.
So let me summarize to bring the pieces together. A person realizes they may have an injury, they hire an attorney, a complaint gets filed,
Right.
the documents get exchanged, the depositions take place. A couple of years have gone by now, and we're getting ready maybe to start talking about a trial. What's the first step in a trial process?
So, as we've already discussed, there are 1,300 cases now. Maybe by the time that we start thinking about, which cases get set for trial, there are going to be 5,000, 10,000 cases filed. Which cases get filed first? So we will sit down with the defendant and put together an initial trial process, sometimes called a bellwether process, which is the process of identifying which cases get worked up for trial first. And that's a whole part of the discovery process where we're identifying handfuls of cases that get worked up, that get expert review, that get in-depth depositions taken. And through that bellwether process, the cases get winnowed down to ones that we can select for trial.
And does the court play a role in that bellwether selection process?
It depends. Every bellwether selection process is different. Sometimes the lawyers can work out a system where the judge doesn't have to do anything. Other times the parties don't agree, and they'll come down to a handful of cases and they'll ask the judge to pick the ones that ultimately get set for trial. Each bellwether process is different.
And at the end of that bellwether process, trials start taking place.
That's correct, unless the parties can reach a settlement before that time, which is always the goal. The bellwether process is the process by which you start trying cases, and usually the first cases are tried before the judge that has been picked for the coordination, at least in the JCCP, or if there's the federal consolidation of cases, it'll probably be before that particular judge. Every case is different. That's a rule of thumb that we've seen in other litigations, and probably have a good expectation that'll occur here.
And I guess some of those cases will go to verdict, and we'll find out what the results are. And in a perfect world, or in a world that's efficient, maybe settlement negotiations could begin to take place because the parties have an idea what the cases could be worth.
Mm-hmm. That's correct. Settlement negotiations can occur before trials begin, during trials, after trials. After trials could be immediate. After trials could be years later. There's no set pattern that is predictable for any one particular litigation.
Yeah.
They're all different.
And sometimes we've seen the cases will be settled where the whole litigation is being discussed in the negotiations, and sometimes the defendants are picking off individual cases that they don't want to go to trial and just settling those individual cases. And sometimes they're working with one law firm to settle that firm's cases, and then they go to the next law firm, and so on. Again, is that a predictable process, or is it going to be, you just wait and see?
Yeah, you wait and see. Sometimes a defendant wants what's called global peace. They want to just get rid of the entire litigation, and they'll offer all the lawyers a certain sum of money and ask the lawyers to split it up among themselves. Other times they just want to take out certain law firms, and they may go law firm to law firm and say, all right, we'll give you X number of dollars for your clients, or X number of dollars for Mrs. Smith, and X number of dollars for Mr. Brown. It's all different, and there's no predictability. And although it's fun to talk settlement,
it weighs off.
Yeah.
What happens in terms of figuring out how each claim gets valued relative to the other claims? Is there some formula that is developed? What's typical? What's possible?
That's a really good question. In any litigation, there are different gradations of injury. So in a case that you and I worked together involving women who got hormone therapy, some women had double mastectomy, some women had single mastectomy, some women had ovarian cancer, some women had metastasis, other women did not. And so there are large groups that you can generally segregate and assign a certain value to each of those groups. It sounds crass, I know. I mean, it's not an easy thing to talk about an injury in terms of dollars, but the reality is that's what we have. We're not going to take away Gilead's license. We're not going to put them out of business. We're not going to send their people to jail. This is a civil lawsuit, and the civil lawsuit talks about monetary compensation, and so we try to do it as fairly as we possibly can to make sure that people who are injured in a similar way get a similar value for their claims.
Is there a process where there's an independent review? Like, does the court get involved in looking at how these cases are ultimately valued on those different groupings?
Sometimes the judge will get involved, but usually not. Usually the lawyers will go to a special master, or go to a mediator, or go to somebody who they can trust to help move the cases in a fair settlement format. Usually it's not the judge who gets involved in assigning values. But they may appoint somebody, or just ask the parties themselves to talk and find somebody that's mutually acceptable to both of them.
So there's like a third party that's sort of independent of the process, that's looking at the process to make sure that across all the plaintiffs it's an even-handed process.
That's exactly right.
What about liens that people may have? People have health insurance, and the health insurance may have a right to be reimbursed, or they got money from the federal government because they're on Medicaid or Medicare. How does that process play into this?
Annoyingly, is my best answer. Health insurance companies, Medicare and Medicaid, have a right to get their money back for any compensation that a client receives for an injury that the insurance company may have covered. So if an insurance company paid for kidney dialysis, that insurance company has a right to get its money back from the settlement for the cost of that kidney dialysis. Now, usually that amount is negotiated down. They don't get a full dollar for dollar compensation, but the lien process is messy and it's long and it's unfair. Clients don't get the premiums back. It's a part of a statutory process that Medicare and Medicaid get to be reimbursed, and it's part of your individual contract with your private carrier, your private insurance carrier, that says they get to be reimbursed if you were injured and then made a recovery for that injury.
Do the claimants in some cases get credit for the attorney's fees? Does the carrier have to bear their share of the attorney's fees?
That's our argument. We argue that it shouldn't be a total windfall to the insurance company because we did all the work. So we don't actually take an attorney's fee.
It just gets discounted from.
That's great. It's just less money that we have to pay to the insurance company. So it's less money that gets taken away from the client. We will never get more than the agreed upon percentage of in our contingency fee contract with our client. So a client will not be paying more than the percentage agreed to in the contract.
I know that one of the topics with universal health care and that comes up is medical bankruptcies. Is that something that happens in these cases, and how does that get handled as a part of the case?
Yeah, so many times people come to us, they have either been in bankruptcy or they file bankruptcy during the course of the litigation. When that happens, the right to recover is no longer the client's, but it's the trustee in bankruptcy. So the trustee is the one who has to approve the settlement, and only the trustee can sign off on a settlement release. So if a client has been in bankruptcy, it may be reopened if there's money that may be available. It depends on what the trustee wants to do. Or if the bankruptcy is open, we need to be working with that trustee collaboratively because we can't settle the case without the approval of the bankruptcy court.
Rob, I want to thank you for sitting with me and going over this litigation and helping explain to everyone that we're representing or people who are interested in this how this litigation is going to move forward. I know if people want more information, we have a website. It's tenofferproblems.com, and we also have a toll-free number. It's 866-516-0270. Rob, if anybody wants to email you if they have a question, how would they contact you?
Sure, they can email me directly at rjenner, R-J-E-N-N-E-R, at jennerlawfirm.com. And I'm pretty good at responding to emails. You'll hear back.
Yeah. And if you want to reach me, it's michael@monheit.com. That's MONHEIT.com. So thank you very much for watching this video. And if you do have questions, we're happy to answer them. Feel free to reach out.